Ladies and gentlemen, today we will see how the property is to be divided among the Hindus in the event of a death of a person. If a person dies, we will have to see whether the person has left any will or not. Supposing the person left any will and he mentioned that his properties or his estate has to be distributed among the legal heirs, or if he specifies that a particular property should go to his son and a particular property should go to his daughter, like that, if he mentioned anything, then the will come into effect and the property has to be distributed, shared as per the directions of the will. Suppose a Hindu executes a will and makes a bequeath stating that all his property should go to his son, then the entire property will go to his son. Similarly, if the person makes a will and say that some of the property should go to temple and some of the property should be utilized for public purposes and some of the properties has to go to his relatives as per the stipulation made in this will, then accordingly these properties has to be disposed as per the direction given in the will. This is called testamentary succession. So, supposing a person executed a will, then all the properties shall be distributed or disposed or shared or divided as per the directions given in the will. Supposing the person did not leave any will, then it is called non-testamentary succession. So, non-testamentary succession means a succession made without any will. That is called non-testamentary succession. So, supposing the person dies is a Hindu, then automatically the Hindu Succession Act will apply. As per the Hindu Succession Act, it stipulates two types of distribution of the property. It stipulates, one of the section 10 stipulates how this property should be shared in the event of a person dies is a Hindu male. Section 8 to 8, 9, 10, 11 and all says how a property should be distributed among the legal heirs in case the person dies is a male, Hindu male. Similarly, section 15 deals about how the property should be shared in case the person dies is a Hindu female. So, for a male, one set of rules are there. For a female, another set of rules is there. So, as per section 8, if a person dies is a Hindu male, all the property left by the deceased should be given to the first class legal heirs mentioned in the Hindu Succession Act. So, if a person dies, his property should go to first class legal heirs. If a person does not leave any first class legal heirs, then in that case, all his property should go to second class legal heirs. If there is no second class legal heirs or first class legal heir, then the property should go to agnates of the deceased. If there is no agnate, then the property should go to cognates of the deceased. So, the choice is 4. there are four choices. Firstly, upon the first class legal heirs, if there is no first class legal heir, then the property should go to second class legal heirs. If there is no first class or second class legal heirs, the property will go to cognates of the deceased. If there is no cognates also, then it will go to cognates. Now, automatically you will ask a question: who are all will come under first class legal heirs and who are all will come under second class legal heirs? So first choice is to first class legal heirs. So if a person dies and leaves any one of the person or any few persons in the first class legal heirs, then his property should be shared or distributed or divided among the first class legal heirs. Mother, wife, children, grandchildren, great grandchildren, all will come under the category of first class legal heirs. So mother, wife, children, great grandchildren are the first class legal heirs to the Hindu male. Supposing a person dies and leaves his wife and one son and one daughter, there will be three legal heirs: son, daughter, wife. So if he left a property, then the property should be divided into three categories and each share will be entitled to get one share each. Okay. Supposing the person left wife, son and daughter's two children, then there will be four legal heirs: son, wife, son, daughter's grandchildren, daughter's daughter, daughter's son. So in that case, again this property has to be divided into three units. One third goes to mother, wife, and one third will goes to son, and the remaining one third will be shared equally among the sons and daughter of the deceased daughter. Okay, granddaughter and grandson will take half of share of their mother. So this is the rule specified for Hindu male dying intestate. So if there is no first class legal heir, then it will go to second class legal heirs. The important thing we have to note in this category is that the father comes under second class legal heirs. As far as the mother is concerned, she is a first class legal heir. So mother is entitled to take her one share along with the wife and children of the deceased. So supposing there is no mother, wife, children or great grandchildren, then in that case, if there is no legal heirs, first class legal heir, then the rule 2 will apply. Then the property will have to be distributed among the second class legal heirs. Among the second class legal heir, the first category is father. Then in second class legal heir, the act stipulates the people under 9 categories were mentioned under second class legal heirs. Among the second class legal heir, the first category will get the first choice. If there is no person in the first category, then it will go to second category. If there is no legal heirs in the second category, then it will go to third category. Like that, one after other will come. So the first category will take the entire estate and they will exclude the other categories. Like that, the law will apply. So supposing the male Hindu dies, and he did not leave any first class legal heirs, and he left only his father, and he also left some other legal heirs who come under second category, third category, fourth category. Then the second category, third category, fourth category people will not get any share. First category alone will get a share. Suppose first category is there is no one is in first category and there is no second category and the third category is there, and the third category will get the property and he will exclude all the other subsequent categories of the people coming under the second class legal heirs. So this is the rule to Hindu male dying intestate. So as far as the female is concerned, section 15 of the Hindu Succession Act stipulates the rules of distribution. As per the section 15, if a Hindu female dies, then her property will be shared among sons, daughters and husband. So sons, daughters and husband will take equal share. Supposing here we have to see one important thing. As far as the male is concerned, the mother of the deceased male will get a share. She will come under first class legal heir. To a female, the mother will not come as a first category person. She will come only as a third category. So female's mother will not get priority in law of succession under the Hindu Succession Act. So if the Hindu female left sons or daughters and husband or sons or grandchildren or great grandchildren, then they will get priority and they will get one share each. If there is no first category, then the heirs of the husband will take this their property. If the heirs of the husband is not available, then father and mother of the female Hindu will take the property. Then if the father and mother also not available, then the heirs of the father, in the absence of the heirs of the father, lastly on the heirs of the mother will take the property. So this act, there is a section 15 of the Hindu Succession Act reads as follows: the property of a female Hindu dying intestate shall devolve according to the rules set forth in section 16. Firstly, upon the sons and daughters and husband, including children of any predeceased son and daughter. Secondly, upon her husband. Thirdly, upon mother and father. Fourthly, upon heirs of father. And lastly, upon the heirs of mother. So this is the rule to a Hindu female dying intestate. So these heirs will get the property as per the sections stipulated under the Hindu Succession Act. So I hope this video will help you to know how the property has to be distributed among the heirs of the Hindus. I hope this will be useful to you, and if you like this video, give a like. You have any opinion or comments, please report the same in the comment section. Your comments will be a really helpful thing to me to make effective videos in future. If you want to learn law or if you want to gain knowledge, you can watch my videos. If you want to watch my videos in Tamil, you can see Raziaq, Sattam, Arivom. If you want in English, you can watch this Raziaq Law Tube. You can watch so many topics, so many playlists which are available in my law channels. In addition to that, if you are not able to clear your doubts, you may also contact me to get legal opinion consultation, either in phone or in person. So I hope you will enjoy this video. I will come again with another topic. Till then, goodbye. Raziaq Ali.